Good evening, ladies and gentlemen, distinguished guests, esteemed members of the legal fraternity from both the bar and the bench, and valued participants from India and overseas. It is a privilege and an honor to welcome you all to the inaugural session of the 5th edition of the ICA International Conference on Arbitration in the Era of Globalization, as we gather to embark on what promises to be an enriching and intellectually stimulating conference ahead. We now proceed to the ceremonial inauguration of the conference. I most respectfully request the Honorable Chief Justice of India, along with the distinguished dignitaries on the dais, to kindly light the ceremonial lamp, symbolizing the dispelling of darkness and the ushering in of knowledge, wisdom, and meaningful deliberations. Thank you, sirs and ma'am. And I now request all present to kindly rise for the national song as we honor the spirit of our nation and mark the commencement of this significant gathering. Thank you. We can now be seated. Ladies and gentlemen, without much ado, we now move to the felicitation of our distinguished guests. As part of ICA's sustainability initiative, we're delighted to welcome and felicitate our distinguished guests with green certificates, each symbolizing a pledge, with trees being planted at Ram Bhumi, Ayodhya, Uttar Pradesh. We are honored to have with us Honorable Mr. Justice Suryakant, Chief Justice of India. I would request Dr. N.G. Khaitan, President ICA and Senior Partner Khaitan & Co., to kindly felicitate Justice Kant with the Green Certificate, marking the planting of a thicket of 10 trees in his honor. Thank you, sir. We're also privileged to have Shri Taranjeet Singh Sandhu, Honorable Lieutenant Governor of Delhi, with us today. I would request Mr. Arun Chawla, Director General, Indian Council of Arbitration and former DG FICCI, to kindly felicitate Shri Sandhu with the Green Certificate, marking the planting of a thicket of 8 trees in his honor. Thank you, sir. As we open the inaugural session, I take the opportunity to invite someone who brings with him a wealth of experience flowing from the confluence of law, policy advocacy, and the advancement of institutional arbitration in India. Ladies and gentlemen, it is my privilege to invite Mr. Arun Chawla, Director General ICA and former DG FICCI, to deliver his welcome address.
Ladies and gentlemen, it's both an honor and privilege to welcome you all to the 5th edition of the International Conference, Arbitration in the Era of Globalization. This gathering is not merely a conference, it's a meeting point of global minds, where law, commerce, and policy converge to shape the future of dispute resolution. This evening would not have been possible without the gracious presence of a towering figure of India's judiciary, whose leadership continues to inspire confidence in the rule of law and future of justice in our country. Ladies and gentlemen, please join me in giving a truly thunderous applause as we welcome our chief guest, Justice Suryakant. Highest traditions of judicial excellence in integrity, institutional foresight, and a deep commitment to strengthening access to justice. A jurist of exceptional integrity, he has consistently used an iron hand against corruption, emphasizing that it poses a serious threat to governance and common citizens. His current tenure reflects a relentless focus on reducing backlogs, particularly in the complex constitution bench matters, alongside a deep commitment to mediation. Mediation is something which he often describes as the DNA, India's inherited DNA. Under his stewardship, India's judiciary has embraced a pro-arbitration approach, reinforcing the vision of making India a global hub of arbitration. Ladies and gentlemen, I'm equally privileged to welcome Sardar Taranjit Singh Sandhu, Honorable Lieutenant Governor of Delhi. With his distinguished diplomatic career spanning over 3 decades, including his tenure as India's ambassador to the United States, he brings with him a profound understanding of global commerce, strategic diplomacy, and international engagement. His experience at the highest levels of global policy making offers invaluable insight into the intersection of trade, governance, and economic cooperation, all of which are critical to the positioning Delhi as a credible and globally competitive hub for arbitration. In his present role as Lieutenant Governor of Delhi, we firmly believe his leadership aligns seamlessly with India's broader growth trajectory and strengthens our collective aspiration to establish Delhi as a preferred global center for arbitration. Ladies and gentlemen, we would have been privileged to have in person Miss Baroness Sue Carr, the Lady Chief Justice of England and Wales, UK. However, due to the unfortunate geopolitical developments, she had to cancel her trip, but very kindly has sent a video message instead, which we will soon share. I welcome her in absentia. As global commerce becomes more interconnected, we are simultaneously witnessing increasing geopolitical shifts, regulatory divergence, and economic uncertainty. It then falls upon emerging powers and civilizations like India to ask some defining questions. Is globalization only about expanding markets, or equally about strengthening the systems that sustain trust across borders? And is it time for India to play a more prominent role in shaping the rules of a new global order that is driven not only by profit, but also certainty, fairness, and the rule of law? Answering these questions is critical to ensure the mutually beneficial sustenance of a globalized and multilateral system that could facilitate cross-border commerce. In this context, today arbitration and mediation have emerged as the cornerstone of investor safety and trustworthy mechanisms across the globe. Jurisdictions such as New York, London, Singapore, Hong Kong, and Dubai have emerged as leaders in arbitration, which is built not just on infrastructure, but on credibility, neutrality, and time-bound resolution. And it is precisely this benchmark that inspires our collective vision to position India as a preferred, reliable, and globally competitive seat for arbitration. India, ladies and gentlemen, at this very moment, stands at a moment of immense opportunity as well as responsibility. With its growing economic footprint, expanding trade corridors, and a judiciary that has consistently upheld party autonomy and enforceability, India is well positioned, as well as now required by prevailing uncertainties, to emerge as a key player in the global arbitration ecosystem. Ladies and gentlemen, in a world where borders are increasingly fluid, but uncertainties are rising, the true measure of globalization is not how freely we trade, but how fairly and efficiently we resolve our differences. And on that journey, arbitration is not just another alternate dispute resolution mechanism, it is a bridge between commerce and sense of security to its stakeholders. Before I conclude, it would be truly unjust not to acknowledge our distinguished international speakers who have traveled from Singapore, United States, United Kingdom, Switzerland, UAE, Germany, and Russia to be with us today, bringing with them a wealth of experience and a truly global perspective that enriches this dialogue. I must also acknowledge the presence of some of the sitting judges and esteemed judges of the Supreme Court who have been at the bench, Justice Sikri and just judges of the High Court. Welcome you here. I must also acknowledge the presence of ambassadors, high commissioners, and members of the diplomatic community of many countries who have joined us today. With these words, it is my privilege to invite Dr. N.G. Khetan to come and deliver his opening remarks. Thank you.
Good evening. I think the 5th edition is actually a misnomer. 5th edition in India, but many, many more editions outside India. In fact, in last 1 year, we had 4 international conferences starting from Australia, Riyadh, Singapore, and London. So this was in last 1 year, sir. So 5th edition is a misnomer. We have been doing it for a number of years. So I'm really very grateful today. Today we have amidst us our Chief Justice of India, Honorable Mr. Justice Suryakant, Sri Taranjit Sandhu, the Lieutenant Governor of Delhi. Then we have in absentia the Chief Justice of England and Wales. We have our international speakers from 11 countries. We have the ambassadors and the high commissioners from different parts of the world today. We have the judges from the High Court. We have the judges from the Supreme Court. I mean, we have the members of the entire legal fraternity. I mean, the crowd, sir, which you see here is about 300, but there are 300 people in the other room who are watching these proceedings. So therefore, we have a double of the crowd than what we are seeing here just now. Sir, Mr. Chawla has already expressed his thanks and gratefulness to our Chief Justice and Honorable Justice and our Lieutenant Governor. Most of you would know the background of our Honorable Chief Justice, but I think many of the people from the international community would not know his background. Sir, he came from a small village. He came from a very small village. He studied from a very small village. And he started studying English from class 6, if I'm not wrong, sir. He started studying English from class 6. And then he was very interested to do law. He started practicing in a small district court called Hisar. And one of the days when his senior was not there, he was arguing before a district judge. And he was so impressed by his argument that he requested a few of the judges that this particular lawyer is not fit to practice in district court. He has to be taken to the High Court. So he was taken to the High Court and he started practicing there. He had been the youngest Advocate General of Punjab and Haryana High Court at the age of 41. At the age of 41, he was elevated as a judge of the Punjab and Haryana High Court, and now we see him as a Chief Justice of Supreme Court and now a Chief Justice of Supreme Court. Sir, as far as our Lieutenant Governor is concerned, sir, again, he's a person from Indian Foreign Service. He was responsible for setting up an embassy in Ukraine. He has served United Nations. He has served Sri Lanka, many other countries. But you see, what is the pinnacle? What is the ultimate office which an IFS officer can hold? And that is to be the ambassador of India to the United States of America. So before holding this office, he was an ambassador to the United States of America. That's the highest office which an officer can hold. And now he's a politician, and he's now sitting as a Lieutenant Governor of New Delhi, one of the most prestigious offices, sir. Sir, Indian Council of Arbitration is the oldest arbitration body, at least in India. We have over 6,000 members. We have over 3,000 expert arbitrators. We have a cooperation treaty with 44 countries. Last year in England, we signed an agreement with the Royal Institute of Chartered Surveyors, which is the largest ADR body in the world. Then we have been holding workshops not only in metro cities. We are going to small cities, small towns, holding seminars, symposium, holding workshops on mediation. Recently, at the request of the Honorable Law Minister, We went to Bikaner and held a mediation course there. So we are very active, not only in India, not only in metro cities, but in small towns, small districts, and also internationally. Sir, no economy can survive, nor it can grow unless we resolve our disputes in a timely and in an effective manner. Today, the world is looking at India. It's a new India. It's a golden India. We are now the fourth largest economy in the world, and by 2028, we'll be the third largest economy in the world. Sir, you will be shocked to know that in the fourth quarter of 25-26, our GDP rose by 8%, the highest in the world ever. And there is continuously growing at the rate of 7%. And even at this time of the war, the prediction is that we will continue to grow at the rate of 7%, the highest in the world. We have now an FTS, free trade agreement, with European Union. We have a free trade agreement with ASEAN. We have a free trade agreement with Australia. We are soon going to have a free trade agreement with New Zealand. I mean, and what is important, that we are a member of BRIC countries, which are a member of 10 members of the BRIC countries, 10 partner members, and their GDP is $77 trillion, and of G7 countries, the GDP is $55 trillion. So therefore, as a member of BRIC countries, not being a member of G7, though we are invited there, we are the largest economy in the world today as a member of G7 countries. I think that calls for an applause. Sir, why we are having, and we requested the Chief Justice to be here, because we feel that he is one Chief Justice who is totally pro-arbitration, who is totally pro-mediation. So I will give some of his quotations. On 1st of March, sir, on 2026, our Honorable Chief Justice said, mediation must be preferred mode of delivering justice. Mediation must be the preferred mode of delivering justice and not the last. On 31st of January 2026, while addressing French Chamber of Commerce in Paris, he went on to say, India has a friendly legal system. Then on 26th November 2025, this for the first time ever, we had a global bench sitting in the Supreme Court, where the Chief Justices and some of the senior judges of the High Court sat with him to see that how our court proceedings takes place. Then on 27th of February 2026, he went on to say that the court should not hurt investment climate. A very, very positive statement that the court should not hurt investment climate. Good for you all, sir. That's what our Chief Justice said. And the first time ever, the Chief Justice of India went to lay at a height of 11,500 feet. And he said, the law must go to the soldiers. The soldiers cannot reach the law. What a statement, sir. What a statement. We are really grateful to you. Sir, for us, award is just not a document. Award is a very sacrosanct document. And now for you all, sir, we are permitting the foreign lawyers also to come and practice in India in a non-litigious matter. Sir, if you look at the world today, and if you divide into this group of subdivision which we have made, you will undoubtedly see that India undoubtedly holds a very, very bright spot. And now, in days of this geopolitics, and which we see all over the world now, there is a total uncertainty, and India continues to stand out as a safe haven. And in fact, it is one of the safest harbor to do business in the world today. Sir, I would beseech upon you. I mean, I don't want to. Tomorrow is a day when we'll have a law minister and we'll have our Solicitor General with us, where I'm going to make few suggestions. Today, sir, we had a roundtable conference, sir. In that roundtable conference, there was some suggestion which I thought I will bring it to your notice, sir. One was if the court could reconsider and review Section 44 of the Arbitration and Conciliation Act in relation to the enforcement of foreign award is concerned vis-a-vis the reciprocating countries, because they have to be a member of New York Convention. The other was, sir, that enforcement of foreign award is concerned, if we can revisit the Civil Procedure Code to increase the reciprocating countries. The third was that everybody felt in our roundtable conference today, sir, that the time has come when we must go for an institutional arbitration world over. All our speakers who are from different parts of the world, in their countries, sir, practically there is no ad hoc arbitration. There is all institutional arbitration. And in fact, the lawyers from India also felt that a time has come that we must promote institutional arbitration. So if you look at the survey today, sir, we took out a survey, my firm took out a survey where 95% of the corporate felt that they would like to resolve their disputes through mediation and through institutional arbitration. Sir, I can only say that the institutional arbitration for you all, sir, that the India provides and offers the cheapest institutional arbitration in the world. We have 2 million lawyers, sir, 2 million lawyers, 70,000 lawyers graduates every year. Our laws, our judgments, sir, at one point of time, it was not referred to in many other countries, but I can tell you, sir, our judgments of the Supreme Court now are referred to in many countries in the world. In fact, sometimes I had an opportunity to refer to our Supreme Court judgment, and with great respect, they look at our judgment and respect our judgment because we are so thorough in law. Sir, I would only appeal to you, and it has been our endeavor, that India should also be promoted as a destination for global arbitration. And I can tell you, sir, we will not fail you. If you all come and arbitrate in India, we shall not fail you. If you have judges like Justice Suryakant, and I told you how he felt. He felt that, for him, the arbitration has to be timely. For him, he said that what is the Supreme Court felt. He said there's no interference. This is what the Supreme Court feels. And if Supreme Court feels that way, sir, I think I will beseech upon you to go for an arbitration, to go for a mediation. Thank you very much, sir. Thanks a lot for being there with us.
Thank you, Khaitan sir, for your insightful remarks and for giving us an inspiring start to the further deliberations. Ladies and gentlemen, I'm delighted to share that we also have a special video message from the Right Honourable Lady Justice Sue Carr, Baroness Carr of Walton-on-the-Hill, the Lady Chief Justice of England and Wales, who has graciously extended her support to this conference. With the kind permission of the dignitaries on the dais, I would now request the same be shared with the gathering.
Good morning. It is a great pleasure to send my greetings to the 5th edition of the Indian Council of Arbitration's International Conference, themed this time on arbitration in the era of globalization. I'm grateful to have been invited to deliver an address at the inaugural session alongside the Chief Justice of India. I would like in particular, if I may, to acknowledge and thank the Honourable Mr. Justice Suryakant, Chief Justice, for his leadership, and the Indian Council of Arbitration for convening this timely and important conference. I regret that I'm unable to be with you in person. I send my very best wishes for a successful, productive, and forward-looking programme over the next 2 days. The United Kingdom and India share a long-standing relationship between our judiciaries, and I place great value on the ties that have developed through sustained judicial dialogue and professional engagement with the judges in England and Wales. Our jurisdictions share common law foundations and, crucially, a common commitment to the rule of law. These shared principles provide a strong basis for continuing collaboration and mutual learning, whether in the administration of justice, in approaches to procedural fairness, or in strengthening the confidence that parties place in dispute resolution processes. Your conference theme, Arbitration in the Era of Globalization, could not be more relevant. arbitration plays a vital role in supporting cross-border commerce and investment, and in providing a reliable and efficient means of resolving complex disputes. I'm especially interested in your discussions on the future of arbitration and the role of AI and legal technology in a digital era. As our courts and tribunals consider the opportunities presented by technology, digital hearings, electronic evidence, new tools supporting case management, it is essential that innovation is matched by a continued commitment to due process, transparency, equal participation, and fairness. I really hope that I will be getting an update on the ideas and the practical lessons that emerge from your discussions. In that context, I think it's also valuable to recognize the broader environment in which our legal communities are operating. As cooperation between India and the courts of England and Wales continue to develop, alongside evolving collaboration under free trade and investment frameworks, there are significant opportunities for further strengthening legal cooperation and professional engagement between our two countries. A strong, predictable dispute resolution landscape supports economic confidence, and it also creates meaningful opportunities for the legal services community in both our jurisdictions, including in arbitration, mediation, and related advisory work. Can I then conclude by emphasizing the importance of strong institutions and constructive judicial support for arbitration? The courts play an essential role in upholding the integrity of arbitral processes, respecting party autonomy, enforcing awards where appropriate, and safeguarding fairness. In an era shaped by globalization and by the increasing speed and complexity of international disputes, international cooperation and shared learning between judiciaries is more important than ever. I look forward to deepening that cooperation, including on the effective and responsible use of technology, building on our previous engagements, and including the e-courts work. Can I wish you all a very successful conference, and I thank you again for the invitation and for your commitment to advancing arbitration and dispute resolution. Thank you.
At this juncture, ladies and gentlemen, I would now like to invite Sri Taranjit Singh Sandhu, Honorable Lieutenant Governor of Delhi, to deliver his special address and share his vision with us.
Honorable and respected Chief Justice of India, Mr. Justice Surya Kanji, President ICA, Dr. Khaitan, Director General ICA, Mr. Arun Chawla, Vice President ICA, Ms. Geeta, esteemed members of legal fraternity, arbitrators, experts and delegates, friends from media, ladies and gentlemen. It's a pleasure for me, especially as a non-technical person, to be present at the 5th edition of ICA International Conference on Arbitration in the Era of Globalization. I compliment the organizers for bringing together such a distinguished gathering committed to strengthening India's dispute resolution ecosystem. Let me acknowledge the role of Indian Council of Arbitration as one of India's oldest and most significant arbitral institutions. Over the years, it has administered thousands of arbitrations across domestic, international, and maritime domains, reflecting both its institutional maturity and the growing confidence of the users in institutional arbitration in India. In today's deeply interconnected world, Economic activity transcends borders. Trade, investment, supply chains operate across jurisdictions, making disputes more frequent and complex. In this environment, arbitration is no longer just an alternative mechanism, it is an essential pillar of global commerce. Its value lies in the three core attributes: neutrality, predictability, and enforceability. Together, these provide businesses the confidence that disputes can be resolved fairly, efficiently, and across borders. This is in turn strengthens investor confidence and contributes directly to ease of doing business. As India continues to expand its role in global economy, the importance of reliable dispute resolution systems becomes even more critical. India is increasingly pursuing what is often described as a policy of multi-alignment, engaging constructively with multiple partners across regions while advancing its own national interest. Investors today look beyond market opportunities. They seek assurance of stability, consistency, and trust in institutional frameworks. This is where institutions such as ICA play a transformative role. Going forward, ICA is well placed to act not just as an administrator of disputes, but as a driver of institutional excellence. It can contribute to building global confidence in India as a credible arbitration destination by promoting best practices, enhancing procedural efficiency, and fostering greater alignment with international standards. Equally important is its potential role as a bridge, bringing together government, industry, and the legal community to shape a responsive and forward-looking arbitration ecosystem. In a rapidly evolving global landscape, such institutions must lead in innovation, capacity building, and international engagement. India's broader economic and strategic trajectory supports this vision. As the country deepens its global partnerships and advances its developmental goals, strengthening arbitration aligns with the need for a predictable and rules-based environment for commerce. Delhi, as the national capital, holds a unique position in this ecosystem. It's a home to key institutions of governance, including the Supreme Court of India, central ministries, regulatory authorities, and a wide range of diplomatic missions. It also hosts leading law firms, arbitration practitioners, and corporate entities. This concentration of institutional, legal, and commercial activity provides Delhi with a natural advantage in emerging as a center for arbitration and legal services. The development of Delhi as a global arbitration hub is not merely a matter of infrastructure, but of institutional alignment and sustained policy support. International experience offers useful benchmarks in this regard. Jurisdictions such as Singapore have demonstrated how deliberate policy frameworks supported by strong institutions like Singapore International Arbitration Center and a pro-arbitration judicial stance can create globally trusted arbitration seats. Similarly, London's position as a leading arbitration hub reflects a combination of legal tradition, institutional stability, and consistent jurisprudence. International experience shows that credible arbitration hubs are built through sustained effort, combining strong institutions, supportive legal frameworks, and consistent judicial backing. India already possesses these foundational elements and, with focused efforts, can significantly enhance its global standing. Arbitration in this context is more than a legal tool, it's an enabler of economic growth. It reduces uncertainty, strengthens commercial relationships, and reinforces trust. Conferences such as this are valuable platforms for dialogue and collaboration. They help identify emerging challenges, share best practices, and shape the future direction of arbitration in India. In conclusion, arbitration in the era of globalization is both an economic necessity and a strategic imperative. Institutions like the ICA have a crucial role to play in shaping a modern, efficient, and globally aligned arbitration ecosystem. With sustained effort and collaboration, India can position itself as a preferred destination for dispute resolution, reinforcing its place in the global economic order. Ultimately, arbitration is built on trust, trust in institutions, processes, and outcomes. Strengthening that trust will be the key to India's journey towards becoming a global arbitration hub. Thank you.
Thank you, sir, for sharing your perspectives and providing valuable insights from the administrative leadership standpoint. May I now turn to our chief guest, Honorable Mr. Justice Suryakant, Chief Justice of India, to enlighten the gathering. However, before we invite him, with his kind permission, we would like to first present a short tribute. Sir?
Of justice, integrity is not a choice. It is a lifelong commitment. Justice Suryakant began his legal career in 1984. After enrolling as an advocate, steadily building a reputation grounded in constitutional clarity and judicial discipline. He practiced extensively and went on to serve as Advocate General for the state of Haryana, representing the state at its highest forums with distinction. Elevated to the bench of the Punjab and Haryana High Court, he upheld the rule of law with unwavering resolve, later serving as Chief Justice of the Himachal Pradesh High Court. In 2019, he was elevated to the Supreme Court of India, bringing decades of legal insights to the nation's highest court. On 24th November 2025, a new chapter began. With a vision rooted in strengthening institutional mechanisms, his tenure is expected to further advance arbitration and efficient commercial dispute resolution in India.
Let us accept that growth and grievances are two sides of the coin. The country will grow, grievances will also grow. And for grievances, the choice is with us. Should we throw the people for adjudication to the normal channel, conventional channel, or we provide them a speedy express highway? The arbitration should assume and should work in taking over the role as an express highway. The toll tax may be, but that toll tax should be affordable so that the people prefer that highway. And once you are there on the highway, you must reach that destination as early as possible. That should be the philosophy of the arbitration.
The Indian Council of Arbitration proudly salutes Honorable Chief Justice of India, Justice Suryakant, a torchbearer of justice for a stronger, fairer India.
Ladies and gentlemen, now please join me in welcoming the Honorable CJI with a much louder round of applause.
Shri Taranjit Singh Sandhuji, Honorable Lieutenant Governor, Delhi, Distinguished Chief Justice of England and Wales in absentia, we have Justice A.K. Sikri, former Supreme Court Judge, my former Chief Justice in the Punjab and Haryana High Court, distinguished judges from the High Court of Delhi, led by Senior Most Judge Justice Kameswar Rao, distinguished ambassadors and diplomats, Mr. Arun Chawla, Director General, ICA, Dr. N.G. Khitan, President, ICA and Senior Partner in Khitan and Company, Ms. Geeta Luthra, Vice President, ICA and Senior Advocate in the Supreme Court of India, Dr. Rajiv Mani, Law Secretary, Government of India, very eminent domain experts, speakers and delegates, arbitrators from India and abroad, senior advocates from the Supreme Court, including Dr. Pinky Anand, who is also looking after arbitration as a judge in Bahrain Arbitration and Commercial Court Center, distinguished members of the bar, ladies and gentlemen, friends from media. It is my proud privilege and a profound pleasure to inaugurate the 5th edition of ICA International Conference on Arbitration in the Era of Globalization, Legal Technology, Economic Development and Cross-Border Disputes. This conference brings together a sparkling consultation of judges, practitioners, institution leaders, and policymakers from India and abroad, and that can very well be witnessed from this auditorium, as also the adjoining one, where about 300 more delegates, I am told, are watching this program. Such exceptional gatherings allow us to ruminate on how dispute resolution must evolve in response to a rapidly changing commercial landscape. Globalization has altered not only the scale of commerce, but the assumptions on which commerce rests. Capital now moves across jurisdictions in seconds. Contracts are negotiated across continents without the parties ever meeting in person. And as Lieutenant Governor rightly pointed out, infrastructure projects routinely engage multiple legal systems at once. Yet, beneath this expansion of economic interaction lies a persistent concern. And that concern is, if disagreement arises, will the dispute be resolved fairly and efficiently? The answer to that question determines whether investment proceeds with confidence or pauses in uncertainty. Where people and ideas interact across borders, disputes are bound to arise. Modern commerce understands this reality, and its success does not depend upon eliminating disagreement altogether, but in ensuring that it can be resolved with clarity and predictability. I believe arbitration plays a central role in making this possible. Indeed, it may be time to rethink, and as has been pointed out by Dr. Khitan and Lieutenant Governor Sandhu, that it is no longer an alternative dispute resolution mechanism. Rather, I always prefer to say it that other and preferred dispute resolution mechanisms, which are parallel pathways through which commercial stability is maintained in an interconnected world. Seen from this perspective, the themes of this conference acquire very particular relevance. Each addresses a different aspect of India's evolving arbitration landscape. Together, They point towards a shared objective, namely, strengthening our position as a dependable forum for cross border dispute resolution. Let me begin with the first theme, the arbitration landscape in India, its origins and its reform trajectory. Over the past 3 decades, India has undertaken a purposeful effort to modernize its arbitration framework. Legislative amendments and a progressive judicial mindset have helped align our system with international expectations. These developments have unfolded alongside India's growing role in global trade. Yet, the task before us today is no longer simply one of reform. It is a one of responsiveness to the emerging needs of business. Commercial disputes are becoming more complex every day. Sectors such as digital commerce, renewable energy, and transnational supply chain contracting generate disputes that demand procedural flexibility as well as subject matter expertise. If arbitration frameworks do not evolve in step with these realities, uncertainty begins to reappear. The way forward lies in strengthening regular dialogue between stakeholders such as commercial actors, arbitral institutions, practitioners, and policymakers. Arbitration thrives when it remains attentive to the needs of those who rely upon it. Consultation mechanisms, periodic procedural reviews, and institutional feedback loops can ensure timely reforms. Such engagements help arbitration remain efficient, adaptable, and aligned with the expectations of contemporary commerce. If the first theme encourages us to reflect on reform within arbitration itself, the second theme, namely alternative dispute resolution in India, navigating the quagmire, invites us to reflect on coherence across the border dispute resolution landscape. Despite substantial progress in arbitration, mediation, and conciliation, two wings, mediation and conciliation, have not always evolved in the same way. As a result, their utilization as dispute resolution pathways appears disjointed rather than complementary. Owing to this, parties often revert to litigation even in situations where consensual or hybrid mechanisms could produce faster and more economic outcomes. Commercial actors prefer dispute resolution systems that are predictable yet flexible. They look to mediation where relationships must be preserved, arbitration where enforceability is essential, and seamless transitions between the two when the nature of dispute evolves over time. The response to this challenge lies in consciously building an integrated ADR ecosystem in which mediation and arbitration operate as mutually reinforcing instruments rather than competing alternatives. Such a cultural transition, evolving pre-arbitration mediation frameworks, institutional referral mechanism, and hybrid procedure is vital to emerge as the preferred jurisdiction for resolving complex cross-border disputes. As arbitration becomes more closely integrated with other consensual processes of dispute resolution, it is also being reshaped by technology. Virtual hearings, digital case management platforms, and secure electronic transmission of documents have already revolutionized the conduct of such proceedings. These developments have improved accessibility and reduced logistical delays, practically and particularly in cases where geography once posed serious constraints. At the same time, technological progress brings its new responsibilities. The increasing use of artificial intelligence in decision support tools raises legitimate concerns relating to confidentiality and the preservation of independent judgment. Arbitration derives its legitimacy not only from efficiency but from the confidence that decisions remain the product of impartial human expertise. The solution, therefore, lies not in shunning technology altogether, but in regulating its use through procedural frameworks. Arbitral tribunals must retain autonomy over the manner in which such tools are incorporated into proceedings so that protocols governing cybersecurity and confidentiality keep pace with technological adoption. When governed by such safeguards, technology becomes a powerful ally of arbitration in a fast paced world. As arbitration evolves procedurally and technologically, clarity in the relationship between courts and arbitral tribunal become equally. That is the fourth theme of this conference, that is anti-arbitration injunction, takes us to one of the most delicate aspects of that relationship. Ladies and gentlemen, arbitration depends fundamentally on the assurance that parties' agreements will be respected and that tribunals will be permitted to determine their own jurisdiction and procedure. Excessive judicial intervention, therefore, risks unsettling this assurance and weakening faith in arbitration as a reliable method of dispute resolution. Courts should, at best, remain passive where arbitral proceedings appear manifestly inappropriate, abusive, or contrary to public policy. Judicial oversight, therefore, should not go beyond an essential safeguard within any mature arbitration framework. The real obstacle lies in maintaining a careful equilibrium between autonomy and accountability. Much like the court's cautious approach when reviewing arbitral awards at the post award stage, the grant of anti arbitration injunctions must remain confined to exceptional circumstances. Such restraint preserves the independence of tribunals while enabling courts to remain guardians of procedural fairness. A principled and sparing exercise of this jurisdiction strengthens the credibility of arbitration in the eyes of commercial actors. This brings me to the last and the final theme of the conference, the growing importance of institutional arbitration as a pillar of stability in cross-border commerce. Dr. Khaitan very briefly flagged this issue in his opening remarks. While ad hoc arbitration has historically played an important role in India's arbitration landscape, complex international disputes increasingly require structured procedural environments, predictable timelines, transparent cost breakdowns, and neutrality in appointments are the basic features of arbitration. Institutional arbitrations can address these concerns directly and prominently. Institutional arbitration in India must continue to expand its reach, strengthen professional capacity, and deepen engagement with global best practices. Encouraging parties, particularly public sector bodies and large commercial entities, to adopt institutional rules more frequently will play an important role in this transition. Institutional arbitration can contribute significantly to the development of specialized arbitration capacity both at the bar and within arbitral awards panels. Expanding such capacity and infrastructure across the country will enhance India's position as a global hub for arbitration. If we step back and reflect on the themes that this conference proposes to examine, a common thread becomes clearly visible. And that thread is that each theme addresses a different dimension of the same objective, strengthening arbitration as a fair, efficient, independent, and dependable mechanism for resolving disputes in a globalized economy. The credibility of India's dispute resolution mechanisms will increasingly influence how investors assess the country as a reliable destination for sustained investment. Globalization ultimately depends not only upon the movement of capital but upon stability of expectations, arbitration provides that stability. It reassures investors, supports commercial partnerships, and ensures that disagreement does not become disruption. Before the curtains draw to a close, ladies and gentlemen, I must congratulate the Indian Council of Arbitration for bringing together such an illustrious gathering of experts and practitioners from across jurisdictions. I am confident that the tectonic deliberations over the course of this conference will purposefully contribute to strengthening India's arbitration ecosystem and advance its role within the evolving architecture of global dispute resolution. My best wishes to the organizers, best wishes to the participants, and thank you very much for inviting me, giving this opportunity to share my views. Jai Hind, Jai Bharat.
Thank you, sir, for your profound and insightful address. Your remarks have offered a thoughtful and intellectually rigorous perspective that will continue to guide our discussions throughout the conference. As we bring the inaugural session to a close, I now call upon Ms. Geeta Luthra, Vice President ICA and Senior Advocate Supreme Court of India, to deliver the vote of thanks.
Good evening, everyone, and thank you for giving me this pleasurable task. I start with the quote from Sir Martin Luther King, who said, "The arc of moral universe is long, but it bends towards justice. In today's interconnected world, mechanisms like arbitration and mediation are what will help ensure that this bend towards justice is also having with it enclosed efficiency, certainty, global harmony, and as my Lord Justice Surikant said, that it will have confidentiality, autonomy, and accountability. On behalf of the Indian Council of Arbitration, it is my extreme privilege to propose the vote of thanks at the conclusion of this inaugural session of the 5th ICA International Conference on Arbitration in the Era of Globalization, Legal Technology, Economic Development, and Cross-Border Disputes. At the outset, I want to thank Honorable Justice Surikant, Chief Justice of India, for delivering the inaugural address. I have to thank him both on behalf of ICA and as a woman, as I can see that Justice Surikant is actually helping women, encouraging women, and looking at more women judges, more women arbitrators, and more women participation. Thank you, sir. I would also like to extend my thanks to Honorable Mr. Taranjit Singh Sandhu, Honorable Lieutenant Governor of Delhi, for his gracious presence. Although he said he is not a subject matter expert, I thought that he looked like very much a subject matter expert and said what was what we should be looking at to make India a global hub. I also thank Dr. N.G. Khetan for his insightful opening remarks. I thank Mr. Arun Chawla, Director General ICA, who seamlessly keeps putting everything together, and all of us bask in the glory which Mr. Arun Chawla bestows upon us. It would be remiss if I do not thank members in the audience. First of all, Justice Sikri for his august presence, Justice Rao, Justice Shukla, Justice Khetrupal, Justice Hari Shankar. If I'm missing anyone, I must say I have to thank you all. I also want to welcome Ms. Anand, ASG, retired and now in the Bahrain Arbitration Center, so wearing another hat. I want to thank all the international speakers. It is because of this galaxy of exceptional speakers that this conference is going to be a great success. And I cannot but thank the speakers who are from India, several of them. If I start naming all our friends who are present, I can see people from Chennai, from Delhi, from Bombay, from all parts of India. I can only thank them very extremely. I thank members of the governing body of ICA, all of whom have come in large numbers to be of support and to be participating. In my closing statement, as a thank you, I want to remind everyone two aspects, both which pointed out by Justice Suryakant. Arbitration should be the express highway. And the second remark that it should be the preferred mode of dispute resolution coupled with mediation. So if we look at both of them and see that we can have them in tandem and make that the preferred mode, and perhaps tomorrow make litigation the less preferred mode, I don't know how many of you would agree, but at least let's try and work forward to make all the modes of dispute resolution resonate together and make India a global hub for commercial arbitration and disputes. Thank you so much. Thank you, everyone.
Thank you, Geeta ma'am, for your gracious remarks. As we close the inaugural session, I request all present to rise for the national anthem.
पंजाब सिंध गुजरात मराठा द्राविड उत्कल गंगा विंध्य हिमाचल यमुना गंगा चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे.
As per the program highlights, I now take this opportunity to request Honorable Chief Justice of India, Justice Suryakant, to kindly grace the Legal Tech Expo, organized at the ground floor, and inaugurate the same with the ceremonial ribbon cutting. We will also be honored by the gracious presence of Honorable Lieutenant Governor, Shri Sandhu, to the ribbon cutting ceremony. All in the audience are requested to proceed for the dinner. Thank you.